Si un abogado hoy desea realmente hacer investigación o analizar un fenómeno jurídico serio, no puede hacerlo sin pasar por el campo de la sociología.
La capacidad de reflexionar interdisciplinariamente, la capacidad de entender los fenómenos sociales y de conocer lo que a uno le inquieta de la sociedad desde muy diferentes aristas.
Mejores herramientas para contribuir al progreso cotidiano del derecho y la justicia, que al fin y al cabo es el eje de la misión del jurista verdadero.
La conferencia inaugural de este día se titula De las economías de mercado a las comunidades de mercado. A medida que la propiedad circula, el derecho se reorganiza. A cargo de la doctora Gloria Lee. Gloria Lee fue admitida en el Colegio de Abogados de Singapur en 2012 y tiene más de una década de experiencia en litigio, particularmente en el litigio de seguros, con maestría en Sociología Jurídica del Instituto Internacional de Sociología Jurídica de Oñati en el País Vasco. Actualmente, Gloria Lee es Knowledge Lawyer en Clyde & Co., una firma global con sede principal en Londres. En este cargo, brinda apoyo a los abogados a nivel mundial mediante la realización de investigaciones jurídicas, el desarrollo y la entrega de programas de capacitación, y mantiene a los abogados actualizados sobre los desarrollos legales en la industria de los seguros. Antes de unirse a Clyde & Co., fue una de las cofundadoras de Civic Legal LLC, una firma de abogados especializada en seguros en Singapur. En Civic, Gloria dirigió el Departamento de Compensación Laboral y Accidentes Industriales. El enfoque de investigación de Gloria radica principalmente en la intersección entre derecho y economía y se basa en su experiencia profesional.
So as shared just now, I am currently a practicing lawyer in Singapore. Singapore, I'm not sure if you all know about it, but it's a very small country. We have only about 5.8 million people, and we are also a very young nation. We just gained independence sometime in 1965, so we're just 58 years old. Singapore, we're kind of known for our economic progress and how we managed to come from what they say a third world to the first world country. In the course of my practice in Singapore as a lawyer and also researching into insurance law, I've developed quite a fond interest in understanding how economics intersect with the law. Some people look at it as law and development, so two separate concepts, how the law interplays with development. But how I would prefer to see it is as legal development, as one united concept, and instead of separating it into two different components. My area of specialty is in insurance law. So if any of you are interested in insurance law or would like to discuss further, please feel free to contact me. I've left my contact details in the QR code. So if you need to, you can scan it and it should have my email and my contact details there. So for the purposes of today's discussion, I will start by introducing Polanyi's double movement framework. I'm not sure how many of you are familiar with Polanyi, how many of you like his work or do not like his work. But we'll discuss that later. So I'll start off by talking about Polanyi's double movement. After that, I'll move on to two case studies. The first case study would be about Bikram yoga, which is in the US, and I will see how Polanyi's double movement applies in that context. The second case study, it's something closer to my heart, which is on insurance law. And I will also look at how Polanyi's double movement applies to it. Finally, I will conclude with some observations on the role of the law and Polanyi's socio-economic theory. So we begin with my chosen analytical framework, which is Polanyi's double movement. Polanyi, this gentleman that we have on the screen, he was an anthropologist, so he is very much influenced by history. And he begins his analysis with what he calls the universal history. So it's this pre-capitalist state before we started to have what we know today as the market economies. So it's a lot of subsistence communities, subsistence farming. And Polanyi argued that in such societies, the market is embedded within the society using deep social bonds, which did not require the externality of state-sponsored law. So this would be his first stage, which is embeddedness, when the community and society, they are one together. And then because he's an anthropologist and he looks at history, so he moves on from this very romantic pre-capitalist state to the next phase, which is when we have industrialization. So following industrialization, the law was used to commodify land, labor, and money, so that this concepts, these items can be traded as fictitious commodities. And this is how the market economy began, actually. So it's when economic relations, it's no longer grounded in the social, but in these transactions of fictitious commodities. And this is also when there is a break or a dislocation between the economic and the social. So they are no longer one, but they are two separate concepts quite distant from each other. But what Polanyi says is that after we have such excessive commodification and disembedding, society will fight back. Society will want to protect itself. And this is when we have counter movements. So counter movements are ways by which society can try to re-embed the economy by emphasizing the needs for social bonds. This is a very brief and general overview of Polanyi's idea of a double movement. Of course, it is not free of criticisms. One criticism is that Polanyi, he does not say what a re-embedded economy looks like. So he talks about re-embedding, but he does not say what exactly is it, you know? Are we going back in time to an era of subsistence living? Are we going to forget capitalism altogether? Or are we just talking about something in between, let's say a gentler form of capitalism? We'll hold on to these thoughts, and I will bring you through my 2 case studies, and maybe that would be a ground for discussion. So my first case study would be that of Bikram yoga. For those who are not familiar with it, yoga is a form of ancient exercise that is commonly done previously in India. it comprises of various breathing exercises and poses that people can do to as a form of exercise. So in the past, yoga would be passed down from master to student, and it is within a very close-knit community. So in this community, this would be what Polanyi calls his pre-capitalist state, whereby things are not commodified, things are not traded or so. It was just simply passed down based on the social bonds that bound that group of people. But of course, we're moving on from that embedded society would be the next stage, which is what Polanyi calls the disembedded economy. And of course, there's no better way to look at capitalism than in the US. So Bikram Yoga, it started in the US. And what happened is that this gentleman, the guy you see on the slides, Bikram, he came out with these 26 yoga poses. And he decided that these 26 yoga poses were his and his property to own. So what he did was that he used the law, he used legal mechanisms to try to enforce his property over these 26 poses. So he would do things like applying for trademarks, and to license the use of these 26 poses. So in some sense, you can think of the law as creating a ring fence around these 26 poses. It is exclusive. Only Bikram can use it. If you want to use it, you have to transact on Bikram's terms, which means you may have to either pay him the price that he wants or obtain the license that he is issuing. And it's only then that you can enter you can be part of this property. So in this sense, yoga was no longer a social relationship. It was no longer embedded in society, but it's now simply a property that can be bought and sold. And the law is used as a tool in this sense of enforcing property rights. It is used by Bikram to threaten people who do not follow his ways. So this is what I would call the disembedded economy, where it is not grounded in the social. Then, of course, there comes Polanyi's next stage, which is the re-embedding of the economy. And what we observed in the US was that, and also across the world, was that people did not want to transact on Bikram's terms. They did not want to treat these 26 poses as solely Bikram's property, because, I mean, to them, it is an ancient form of exercise which should be available to everyone. So as with social media, the rise of social media, and people just simply refusing to buy in, people refusing to pay for a license, and very soon Bikram realized that he had no hold over society. So there was no way he could actually enforce this property of his. And what we can observe here would be a sort of re-embedding of the property, whereby the previous ring fence that the law had created is slowly breaking down. But what we can also observe here is that the law actually did nothing. the law was very irrelevant in this case because it did not help to facilitate any re-embedding. It simply had no part to play in this whole process. So of course, this does lead me to the question of in Polanyi's re-embedding stage, is there a role for the law? Or is the law so tainted? Is the law so tainted as a tool of capitalism that it cannot be used to re-embed the economy back to society? And this is just a thought that I would like you to hold on and to think about as we move on to our next case study. So my next case study is, as I've mentioned, something closer to home. I'll be talking about the migrant labor in Singapore's construction industry. So Singapore, we are very heavily reliant on foreign workers who come from Bangladesh or India. A large proportion of them are non-Singaporeans. And I'm not sure about Colombia, but I believe this to be the case in many other countries whereby there's a lot of reliance on foreign labor in the construction industry. And so if we go back to Polanyi's theory, and if we look at what he calls the universal history before industrialization and globalization, labor was actually a form and a part of society, and how society organized themselves, of how some societies organized themselves, was through a guild system, which was headed by a master, and he would have his apprentice. He would train this apprentice to build houses, in the various construction work. And if something happened to the master or to the apprentice, then the guild would step in and look after him or his family. And that's pre-capitalism, before industrialization and before globalization. But of course, this changed. With globalization, people started moving from one country to another, and it also changed our view of labor. So much so that labor is no longer a part of society, but a unit of production that can be traded and transacted. And this was exactly what Polanyi said, where labor is commodified and labor is treated as a fictitious commodity that is traded or transacted. And with this, social bonds would be weakened, because these units of labor, they are no longer part of society, but they are just part of a company's balance sheet. And so what we see in Singapore is that there has been a high injury and death rates amongst our foreign workers. And this is largely attributed to the fact that because they have very poor working conditions, there is not enough care for their well-being and their safety. So this is one illustration of what happens when the economy is separate from the social, that people stop feeling for these units of production in that sense. And this would what Polanyi called the disembedded economy. So of course, the next stage now would be, how can we re-embed them? So what happened in Singapore is quite unique on two fronts. The first is that the government tried to make work injury compensation compulsory. And what that meant was that there would be a safety net for all these foreign workers. If anything happened, they would be taken care of by the insurance payouts. In one sense, it might look a bit like re-embedding, where people are trying to care more for them and trying to absorb them into society. But this method actually did not work out well, because companies with insurance, they just saw it as just another expense to them. The economic was still very much fractured from the social, and in theory it sounded like a good idea in re-embedding them, but in practice it did not work out all that well. So the next thing that the government tried to do quite recently, actually just last year, was that they started criminalizing conducts by directors of companies. So if it was found that a company was not safe for its workers, or they did not have very good working conditions, very safe working conditions, then the directors of the company could be criminally liable themselves. So it was no longer the company who was, not just the company is liable, but the person in charge of the company could also be liable for any wrongdoings that happened. And then this started to change the way companies behaved, because their bosses, the directors, were starting to feel that sense of responsibility for these workers. And that was when on the ground we could see changes happening. So directors were starting to find out what they can do for these workers, how they can make things safer. And quite strangely enough, this is one way that the government had tried to re-embed the economy back into the society by making them a part of this community to care for them. So instead of just seeing them as units of production, they are now internalized into society and they're part of society. And if we contrast this second case study with our earlier case study, what we see is that the law here, or the law and the government here, is playing a more active role in trying to help in the re-embedding process. In the first case study, the re-embedding was more organic. It grew out of social media, of a collective conscience by society to want to make things right again. But if we look at the second case study, here it is quite different. The law does play a more active role. And interestingly, if we contrast the two things that the government had done, one was more successful than the other. One which involved the directors themselves personally turned out to be a better way of re-embedding the economy into society. So having talked about these two case studies, I moved on to the last part of my presentation, which is what are some lessons that we can draw from this two case studies and what we can learn from Polanyi. As mentioned just now, one criticism of Polanyi is that it is a story without an ending. He does not tell us what is the end point. Is it are we just looking at something very romantic about going back in time? And how do we even reach there? Is the law supposed to play a part in the re-embedding? Is society the one who's supposed to play a part in the re-embedding? How does the re-embedding looks like? Is it going to be a massive change where everything is changed at one go? Or is it a more incremental approach? So like the second case study I shared, it wasn't as though something major happened and the whole of Singapore changed, but it's just a very small section in the Singapore economy that is starting to show such change. And I'm not sure whether it's enough or whether such re-embedding is enough, whether it will be sustained or not. And if it's a re-embedding that requires government intervention, then, and it's less organic, is it something that is sustainable? Because has society's conscience changed at all? Or are they just reacting out of fear of the criminal sanctions? My take on Polyani and on the two case studies is that we should not focus so much on the end results. So not so much of, oh, has the economy been re-embedded or not? Instead, I think it is perhaps more meaningful for us to focus on, let's say, the sites of negotiation, how people try to negotiate for re-embedding. Whether it is like in the first case study, I'm just going to ignore whatever the law says about trademarks and copyrights and licenses and just go ahead? Or would it take on the form of the second case study whereby the law plays a more active role? So I put two pictures here on the slides just to illustrate the point that in the first picture, we see nature in its very wild and romantic form taking over a building. Or in the second picture, where there is also some sort of re-embedding of nature within the building itself. So it's really just, I think it's just two forms that we should just embrace. It's not to say one is better than the other. And I'll end off by discussing what the role of the law is. In my slides, I've included a photo of our Singapore Supreme Court. It's a lot of people call it the UFO because of how it looks. So this is what I shared at the start, when how law plays quite different roles in the re-embedding process. And maybe sometimes it's more useful to think of the intersections between law and economy as legal development, rather than two concepts of being law and development. Because if we think of it as just law and development, we are sort of pigeonholing or confining law to a tool, maybe a tool of the development state, or it is a shield to protect the free market mechanism from government intervention. We're not being very open-minded about what the law can be, what the law should be, or whether the law should not even be there. But maybe sometimes it's more useful to just recognize that law can be anything. It can be a means, it can be an end, an obstacle, or as the case study of Bikram showed, it can be just something irrelevant. Instead of being so preoccupied with pigeonholing the law and saying like, oh, the law is a tool, the law is evil, or the law is good. is just to take a more holistic view of the law and to recognize that it can actually be anything. Yes. So this brings me to the end of my presentation. I do thank you all for your attention. I know it's very early in the morning for you. As I've mentioned, if you do need to contact me further, my email is on the slides. If there's any questions or if you'd like to discuss further, I'm happy to take them. If not, perhaps I could pass the time on to Yancy.
Me interesa mucho la obra de Polanyi y me parece que es muy interesante aplicarla a las relaciones jurídicas. En mi caso creo que es evidente que cada vez hay más derechos de propiedad, digamos, de distinto tipo, y que eso tiene que ver con la separación entre la economía y la sociedad, porque el derecho pues sirve para la consolidación, digamos, de nuevas esferas económicas que antes no estaban en la esfera económica, sino en la esfera social. Sin embargo, creo que hay una tensión porque nosotros acá en Colombia tenemos un derecho civil muy antiguo, digamos del siglo XIX, que en su época ya fue una gran transformación. ¿Aló? Que en su época ya fue una gran transformación, una ruptura con formas de propiedad diferentes, antiguas, colectivas, que sí reconocía la ley española, ¿cierto? O las comunidades indígenas, pero pareciera que inclusive ese derecho civil decimonónico, precapitalista, que era funcional al capitalismo agrario, ya no nos sirve inclusive para los nuevos derechos de propiedad, que ahora hay más. Y sin embargo, también hay como otro reflujo con que ahora se reconocen derechos sociales, económicos y culturales, y entonces tenemos un derecho que yo diría que es esquizofrénico en esa materia, pero digamos nosotros tenemos un código civil del siglo XIX y más años de vida independiente, y cómo resuelven ustedes esa tensión, o si la tienen, ya que tienen pues una tradición jurídica diferente y una historia independiente más corta. Entonces, ¿cómo hacen con esa tensión?
I think what is needed is to re-embed the law for your case. Yeah, in Singapore, we are quite fortunate in that we are very young, so we do not have that same kind of tension that a country with such rich history like Colombia has. Yeah, going back to my first comment that maybe in this case, it is the law that has to be re-embedded. We keep talking about re-embedding the economy or property, but maybe now it's for the law to be re-embedded. And I'm not sure what the re-embedding process would be, whether it is social movements or other forms, or just, you know, as the first case study shows, where people are just going to ignore the law. You know, that is also a form of re-embedding. To answer your question, I really do not know how we can ease that tension. But it is a very interesting topic for us to see how the law has many different facades.
Gloria,
thank you so much for having me. It's my great pleasure. Am I supposed to stop sharing the screen?
ok, Gloria, tenía una...
Okay.
¿Hasta dónde podemos ver como un nuevo estudio la comodificación de algunas normas jurídicas, es decir, el derecho como commodity hoy en día, a nivel de trasplantes jurídicos a nivel de contratos tipo en las grandes obras de infraestructura, donde firmas internacionales, muchas de ellas en Singapur, ¿no?, en Hong Kong, en Londres, venden una asesoría cuyo único objeto es entregar un contrato tipo macro que es utilizado para una gran obra civil, un metro, la navegabilidad de un río, una gran represa. Y en este sentido, la labor del abogado también y algunas herramientas jurídicas, tanto a nivel privado en términos de contratos, como a nivel público en términos de leyes, que terminan saliendo no tanto porque los parlamentos así lo quieran, sino porque contratan contratan a su vez grandes firmas internacionales que les recomiendan y les hacen completamente la ley, trayéndola de otro lugar. Entonces, ¿hasta dónde el derecho mismo en este momento se está desligando de su propia sociedad y de su propia economía, y estamos comenzando a trabajar en ocasiones con derechos como commodities en la sociedad global? ¿Y cómo podríamos luego reintegrar ese derecho como commodity, ¿no? O cómo podría reintegrarse, o cómo podemos generar un derecho más propio, ¿no? Un derecho, en nuestro caso, más colombiano, un derecho más singapureano.
You raise very good questions, which is, I think, something that I struggle with a lot as well. I do not have the answer to what the law can do, but to recognize what I do pick up from your question is that there are many actors involved in re-embedding in society. So the individual lawyers themselves, we are also actors, we are also sites of negotiation. And yeah, maybe for re-embedding, we do need to get various actors on board, and this would also include lawyers in bigger corporations.
Buenos días, muchas gracias, profesora Lee. Me gustaría hacer la siguiente pregunta. De pronto es una pregunta difícil para usted porque usted está en uno de los países más ricos del mundo y nosotros no, a nosotros nos falta un poquitico. Entonces, creo que nosotros tenemos una ventaja, y lo digo en serio, incluso lo escribí por ahí en algún libro hace muchos años que se llama Nosotros los subdesarrollados, y es que tenemos una ventaja, y me alegra muchísimo conocer a Poliani, a quien no conocía de verdad, y lo leeré, y es que noto, y aquí hablo desde mi ignorancia, usted me va a corregir si entendí bien o no, que el capitalismo o este progreso absoluto al que, por ejemplo, ha llegado Singapur, donde su Producto Interno Bruto es uno realmente de los más altos del mundo, tiene identificado claramente el problema del capitalismo, pero en países subdesarrollados tenemos la gran ventaja en donde buena parte de muchas situaciones sociales, muchas regiones, muchas relaciones no han llegado ni siquiera al feudalismo. Es decir, nosotros tenemos una sociedad fragmentada en donde alguna parte está insertada en la economía global y otra afortunadamente no. Nosotros tenemos una gran diversidad, una gran pluralidad, tenemos multiplicidad de lenguas, de culturas. Podríamos decir que en la teoría de la desintegración, estos países cuentan con la ventaja de pronto de proteger esos estadios o esas etapas que ni siquiera han ingresado al capitalismo para no esperar a que lleguen allá y tener que devolverlos mediante la desintegración. Es decir, estaríamos más cerca de la solución de hacerlo antes y precaver y prevenir los desastres del capitalismo. Finalmente, el subdesarrollo tiene una ventaja, y es que puede ver el futuro en tiempo real en países como los de ustedes y prevenir muchos de esos defectos. En ese sentido, sé que es una idea un poquito descabellada, pero a veces no vemos nuestras propias ventajas desde el subdesarrollo. No sé si es una pregunta o una aportación a sus investigaciones. Muchas gracias.
Yes, thank you for your observation. When I was at Onyati and I was studying a lot of theories from the South, Santos, and how he describes social movements, I always felt a bit of regret that I grew up in Singapore because, as you've mentioned, we're very sterile. There is no life, there's no energy in a lot of things. Just to give you one quick example, we have this park that is called the Speaker's Corner, and that is where people go there to protest. But before you protest, you need to apply for a permit, and there's a limit as to how long and how many people can be there. And people in Singapore follow it. So that park is usually empty, and there are usually no protests. If there is, it's always very orderly. And such a sterile environment, it does reduce the sites of negotiation and engagement. So that is a real problem I find in Singapore, that a lot of the actors, like just now I mentioned, everyone is an actor in this re-embedding, but a lot of the actors, they are just happy to be silent or silenced. And they just leave whatever has to be done to the government. And which is maybe why in the second case study, if any re-embedding has to occur, it occurs through the government and through the use of the law. Yeah, so in contrast with Colombia, Singapore is very much more sterile. There is just not the same level of engagement. And yes, maybe it's just two different countries with very different backgrounds. And so the re-embedding in Singapore would look very, very much different from the re-embedding that you would have there in Colombia. And how this re-embedding would also take a different form as well. So not to say one is more correct than the other, but it's just very different because of the context they are in.
Quiero referirme a su segundo
Good
estudio.
night.
En su segundo caso,
Yes.
yo tengo dos observaciones. ¿Cuándo es suficiente una reintegración y cuándo hay abuso de reintegración?
I don't think there is actually a stop point for a re-embedment, in the sense that society is moving, things are moving, the economy is moving, and with everything moving, we can't just say that, oh, we've reached this final state of happiness and let's leave it. Because very soon what we have as, if we're going to crystallize re-embeddedness in a state, then maybe 5 years down, 10 years down, it would be different. And people are very smart. I think for now it may work, but people would think of ways to work out the loopholes in the system, etc. And so it has to be a constant process, a constant dialogue between the economy and between society. And what the focus on for re-embedding is not really what the end state is, but how do we keep this conversation going? How do we keep things moving? Yeah, so I don't think, I'm not saying that for the second case study, we are in a good place and this is how re-embedding looks like. This is just one point in time and we need to move on. Things will move on and it's not to crystallize things at a certain state. I hope that answers your question.